My name is Tony Dong. Supreme Court will hear travel ban case Washington. The Supreme Court announced on Monday that it would decide whether President Trump's revised travel ban was lawful, setting the stage for a major decision on the scope of presidential power. Mr. Trump's revised executive order, issued in March, limited travel from 6 mostly Muslim countries for 90 days and suspended the nation's refugee program for 120 days. The time was needed, the order said, to address gaps in the government's screening and vetting procedures. 2 federal appeals courts have blocked critical parts of the order. The administration had asked that the lower court ruling be stayed while the case moved forward. The court granted part of that request in its unsigned opinion. The justices, in effect, said that foreigners with ties or relationships in the United States would not be prohibited from entering the country. But those applying for visas who had never been here or had no family, business, or other ties could be prohibited. The historic moments, head-spinning developments, and inside the White House intrigue, we grant the government's applications to stay the injunctions to the extent the injunctions prevent enforcement of Mr. Trump's executive order, the ruling said, with respect to foreign nationals who lack any bona fide relationship with a person or entity in the United States. The justices said the distinction should be easy to administer. In practical terms, this means that the executive order may not be enforced against foreign nationals who have a credible claim of a bona fide relationship with a person or entity in the United States. Justice Clarence Thomas, joined by Justices Samuel A. Alito Jr. and Neil M. Gorsuch, dissented from part of the court's opinion. They said they would have revived the travel ban in its entirety. While the court considered the case, I fear that the court's remedy will prove unworkable, Justice Thomas wrote. Today's compromise will burden executive officials with the task of deciding on peril of contempt whether individuals from the 6 affected nations who wish to enter the United States have a sufficient connection to a person or entity in this country. The compromise also will invite a flood of litigation until this case is finally resolved on the merits, as parties in courts struggle to determine what exactly constitutes a bona fide relationship, who precisely has a credible claim to that relationship, and whether the claimed relationship was formed simply to avoid the executive order, Justice Thomas wrote, quoting from the majority opinion. In an official White House statement, Mr. Trump hailed the court's action as a clear victory for our national security. As president, I cannot allow people into our country who want to do us harm, Mr. Trump said. I want people who can love the United States and all of its citizens, and who will be hard-working and productive. The United States Court of Appeals for the Fourth Circuit in Richmond, VA, ruled last month that the limits on travel from the 6 countries violated the First Amendment's ban on government establishment of religion. Relying on Mr. Trump's statements during the presidential campaign, where he called for a Muslim ban, the court said the order drips with religious intolerance, animus and discrimination. The United States Court of Appeals for the Ninth Circuit in San Francisco recently blocked both the limits on travel and the suspension of the refugee program on statutory rather than constitutional grounds, saying Mr. Trump had exceeded the authority granted him by Congress. The court agreed to review both cases and said it would hear arguments in October, noting that the government had not asked it to act faster. The court suggested that the administration could complete its internal reviews over the summer, raising the prospect that the case could be moot by the time it was argued. Thank you for watching. For the follow-up, subscribe to the channel yourself here. Circuit's concerns. But new lawsuits were immediately filed, and federal judges once again stopped the implementation. A federal district judge in Maryland stopped the portion of the order affecting travelers from the 6 countries. A judge in Hawaii froze that portion, and the part affecting the refugee programs. Appeals courts on both coasts upheld those decisions. The U.S. Court of Appeals for the Fourth Circuit in Richmond agreed with U.S. District Judge Theodore D. Chuang in Maryland, who sided with opponents in finding that the ban violates the Constitution by intentionally discriminating against Muslims.
Right now,
in a 10-3 decision, the court noted Trump's remarks before and after his election about implementing a ban on Muslims, and said the executive order in context drips with religious intolerance, animus and discrimination. The president's authority, the court said, cannot go unchecked when, as here, the president wields it through an executive edict that stands to cause irreparable harm to individuals across this nation, Chief Judge Roger L. Gregory wrote. Meanwhile, a three-judge panel of the Ninth Circuit said Trump had not adhered to federal law in which Congress gives the president broad power in immigration matters. The Ninth Circuit opinion did not dwell on Trump's public comments, nor did it declare that the president had run afoul of the Constitution, because his intent was to discriminate. Instead, the judges ruled that the travel ban lacked a sufficient national security or other justification that would make it legal, and that violated immigration law. There is no finding that present vetting standards are inadequate, and no finding that absent the improved vetting procedures there likely will be harm to our national interests, the judges wrote. These identified reasons do not support the conclusion that the entry of nationals from the 6 designated countries would be harmful to our national interests. They added that national security is not a talismanic incantation that, once invoked, can support any and all exercise of executive power. In both appeals courts, a minority of conservative judges had said their colleagues were making a mistake. Judges should look only to whether the executive orders were proper on their face, they said, without trying to decide if the president had ulterior motives, and defer to national security decisions made by the executive branch. The Supreme Court surely will shudder at the majority's adoption of this new rule that has no limits or bounds, wrote dissenting Fourth Circuit Judge Paul Veniemeyer. Trump thundered on Twitter after the judicial setbacks that the second executive order was a watered-down version of the first. And while his lawyers in court described the action as a temporary pause in immigration, and administration officials corrected reporters who called it a travel ban, Trump did not agree. People, the lawyers and the courts live whatever they want, but I am calling it what we need and what it is, a travel ban. He wrote, to provide for the nation's security. That includes being able to close the borders based on an evaluation of the potential of foreign threats, at least for now. The Supreme Court justices will fully consider the arguments on both sides next autumn. Of course, by that time it may not matter. The administration has 3 months to conduct its executive review of immigration policy and devise new guidelines. In the meantime, the gates to America just got a bit smaller. The court said it could not uphold lower court injunctions barring enforcement of the ban against foreigners who have no connection to the United States at all. Denying entry to such a foreign national does not burden any American party by reason of that party's relationship with the foreign national, the court said. The court also said it would allow a 120-day ban on all refugees entering the U.S. to go into effect, allowing the government to bar entry to refugee claimants who do not have any bona fide relationship with an American individual or entity. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch wrote in the ruling that they would have allowed the travel ban to go into full effect, pending a review. The ruling hands a major victory to Mr. Trump, who restored a 5-4 conservative majority to the Supreme Court when his nominee, Justice Gorsuch, joined its bench in April. There are 5 Republican appointees on the court and 4 Democratic appointees. Mr. Trump's policy had been left in limbo since it was struck down by federal judges in Hawaii and Maryland, who found it to be discriminatory. Those lower courts ruled against the executive order days after the president issued a revised version with a narrower scope on the 6th of March. The original ban, released on the 27th of January, provoked mass protests at American airports. The president's revised order calls for a 90-day ban on travelers from Libya, Iran, Somalia, Sudan, Syria and Yemen. It also introduces a 120-day ban on all refugees entering the U.S. to enable the government to implement stronger vetting procedures. Mr. Trump issued the orders amid a slew of terrorist attacks in Paris, London, Brussels, Berlin, and other cities. However, critics called the policy un-American and Islamophobic. The president was unhappy about the March order, calling it a watered-down, politically correct version of the first one. January's original executive order included Iraq among nations whose travelers would be barred from the U.S. and imposed a full ban on refugees from Syria. Thank you for watching. For the follow-up, subscribe to the channel yourself here.